it in India, it is not allowed because prior art is global, but patent is territorial. Okay. For example, US. Now let's take this example itself. Now, if US has come up with imatinib, they have filed a patent already in the US. Now, this particular patent is only given when it is disclosed to the fullest. मतलब पूरे दुनिया को वो पता चल जाएगा. Okay. Now, some company from India reads about this imatinib. It has A, B, C, D, E components. They make that particular imatinib in India and again try to patent it. They cannot patent it. Why? Because the prior art is already globalized. Okay, prior art is global. Everyone in the world knows about it, so you cannot patent it in India. Okay, that is very important. But when imatinib was patented in the US, they can enjoy their rights only in the US. That right cannot be given globally. They cannot just get up from the US and start selling that drug in India. Okay, so patent is always is a territorial right, but prior art is global. Is it clear?
Yes, sir.
Okay, understand this difference. So imatinib was already okay. Understand this difference. So imatinib was already patented in the US. So imatinib became a prior art for imatinib mesylate filed in India. Okay, and under section 3D, mere small changes uh, or in the known substance or mere use of the known process cannot be patented. And under that particular act, this particular patent was rejected or revoked. And they couldn't sell imatinib mesylate in it. It was a very big case which went to Intellectual Property Rights Board and then to Supreme Court of India. But even in Supreme Court, in I think in 2012 they rejected the plea. Ah yes, yeah. 2013 they rejected Novartis plea and it cannot go further. It is a very interesting case. And the entire world took the example of this particular case of Section 3D. Okay, so that is why I first spoke about the international development. Then I spoke about different criteria of patentability under Indian Patents Act, and then I spoke about the Glivec case. Okay, did you get the connection now? Okay. Um. So it is 10:30. Anyone has any questions? No questions. Okay. So now simple sections. Now this is the complications are little bit done, but these simple sections are very very important. Okay. So section 6 of Indian Patent Act talk about who can file a patent. So they say that the true and the first inventor of the invention can file a patent. The assignee of that particular inventor can file a patent. Assignee मतलब मैंने जिसको assign किया है, that person can file a patent. Or the legal representative of the deceased or dead person can file a patent. Now you can either file it alone or jointly. That is irrespective. Okay. So these are four things. Who can file a patent? This section is the most important section of the entire Patents Act. Okay, and the entire judiciary system is only based on this single section of rights of patenting. So you can either patent a product or a process. Okay, so let's read it carefully. Where the subject matter of the patent is a product, the exclusive right to prevent third parties, I spoke about the third parties to you. So to prevent third parties who do not have his consent, मतलब मैंने लिख के नहीं दिया है कि तुम कर सकते हो उसका यूज, who do not have his consent from the act of making, using, offering for sale, selling, or importing for those purpose that product in India. Okay, and where the subject matter of patent is a process, the exclusive right to prevent third parties who do not have his consent from the act of using that process, and from the act of using, offering for sale, selling, or importing for those purposes the product directly obtained by that process in India. And your entire Patents Act only is based on these 2 points. That's it. Okay, that means if I am not allowing you to make that particular product, then you cannot make that product. You cannot use that particular technology. You cannot offer somebody else to sell that particular thing to you. You cannot sell that particular thing by yourself. And fifth important thing, you cannot import it in India. Okay, and this particular word is also important for the process, the product made by the patented process, even that you cannot use, offer for sale, sell, or import. Okay. Any questions about these two sections, rather the subsections?
Sir, I have a doubt that suppose I have designed something. So, is it necessary that design to be complete and where it is till the functioning status? After that, we should go for patent, or before prove that that machine will work or not. Before the for the just for design itself, whether we can go for patent.
You can file. Okay. So you usually get a good. You are asking good questions, Dingaraj. So you usually file a provisional patent before that. Provisional patent just has a brief description of what you are going to do. And within 12 months of filing the provisional patent, you file a complete patent. So you need not have the entire design ready finally for getting to the patents office. You can give a kind of supplementary, like a brief information about what is patent all about and different things. But a complete explanation should be given in the complete patent, which comes after 12 months from the date of filing the provisional patent. So you need not have that particular machine working, but you should show the industrial applicability of that particular machine within 12 months, right?
Or,
For
or else it will
example,
be rejected, sir.
you cannot say it is rejected because you haven't filed yet. Because जब तक पैसा नहीं दोगे तब तक फाइल नहीं होता. It becomes void.
Okay. Thank you.
And if you cannot show it, then there are three important words: void, invalidation, and rejection. So I'll talk about those later. Okay, but it will not be considered. I mean, you just have filed a provisional patent to uska koi, you do not get any rights for the provisional patent. Okay, as a provisional application. Now, this particular importing word is really very important. Let's not get into this. Why this particular importing word is important? So suppose many people say that uh, मेरा भाई यूएस में है, सो कैन यू गेट आईफोन फॉर मी बिकॉज वहां पे सस्ता मिलता है. Okay, many of you might have done that. Now, interesting thing you should understand that if I am getting one iPhone for my brother or sister who is there in India, and when I am traveling, I am carrying that particular iPhone with me and I am giving it. I am not legally allowed to sell that particular iPhone in India because मैं free में नहीं देने वाला किसी को, right? I will take money for that. Now people will think एक iPhone से अच्छा है मैं 10 iPhone लेके जाऊँ, which is again not allowed because I am legally buying it in the US and I am selling it illegally in India because I am not authorized to sell iPhones in India. Okay, what do you call such kind of stuff as? Any idea? So let's put it that way. When I'm buying iPhone, that is a white market. When I'm illegally selling it in India, that becomes a black market. So together I am into which kind of market?
Illegal बेचते हैं उसको क्या बोलते हैं?
Any
Smuggling.
answers?
Smuggling, right?
It is not specifically smuggling, it is called as gray market. White and black together. but it has the same penalties as smuggling. So never do that. So there is a principle called as de minimis principle. De minimis principle talks about the minimum amount you can carry along with you to another country without any commercial benefits. Okay, so that is called as importing. Now, if there are legal authorities who can sell iPhones in India and they are buying those iPhones from the US, that is a legal route. If I am buying 10 iPhones in India and I am selling those, that becomes a parallel route. Okay, so this particular type of transition is called as a parallel import. And because of which, what happens? कि India में suppose I'm selling, suppose an authorized dealer of iPhone is selling iPhone for 80,000 rupees and I am selling it at 70,000 rupees. That means people will buy iPhone from me because I am giving them for a 10,000 cheaper price. Okay, and this is where I'm exhausting the rights of the authorized owner. Okay, so this is where this term comes into picture: exhaustion doctrine and parallel import. Okay, so I'm actually exhausting the rights of the authorized personnel because of my parallel importation of these unauthorized goods. Got it? So this is how the things work. And that is why this particular section is very important. Okay, I'll not get into Diamond versus Chakravarti case today because it is very complicated. So this is how the parallel import works. So these are the approved authorities to make the sale. And if somebody is doing unauthorized, then it is called as a parallel import and or gray market goods. मतलब we say, अरे don't worry, don't buy it from there, Crawford Market में मिल जाएगा. So that is what actually is. But now even the genuine goods and counterfeit goods, they have their own. Okay, so that is how the exhaustion doctrine works. You understood what is exhaustion doctrine and parallel import, right? Understood? No. You have those emojis, na? ऐसे thumbs up वगैरह करो. I can see that. Okay, let's move on to the next part, which is transfer of rights, which is one of the very important thing in patents act. वो हर जगह पे होती है. Transfer of rights. So the first is licensing. Oh, somebody has messaged. Oh, Delphin, thank you. I actually missed that particular word, barter system. Yes, transfer of rights. Now, important thing you should understand that if I have the right, I should be able to give it to somebody else, either to gain money out of it or to gain to for the joint ventures. Like, uh, for example, we had Maruti Suzuki. So Maruti is an Indian venture, Suzuki is a Japanese venture, and they combine together. Hero Honda, अभी नहीं है, but Hero Honda again a combined venture. Now Tata bought Jaguar for India. Again, in that particular case, there comes the assignment and licensing part. So, what is transfer of rights? When I talk about licensing, licensing under licensing, you get multiple rights, but not all rights. Okay. So, if I am giving license to a person to use my invention, or to use my patent, not say invention. Suppose I am giving my patent or I am licensing my patent to some other person or another company, that person or that company can use that particular invention for a specific period of time. But if somebody else steals that particular invention, the licensee cannot file a case against them. Okay, this is the stealing is called as infringement in legal terms. So if somebody is infringing my patent right, the patent holder, the original patent holder can only file the infringement suit. The licensee cannot file the infringement suit in most of the cases. Okay, why is this so? Now, अभी people will say कि तुम्हारी property है तुम देख लो. ऐसा नहीं. So when I'm filing an infringement suit, I am actually asking for a good amount of penalty in return. Okay. So suppose I am licensing something and somebody infringes that particular invention, and if I'm filing an infringement suit, then the infringer has to give the original patentee the penalty amount and not to the licensee. Okay. On the contrary, assignment is most of the times to the fullest. So suppose I'm assigning my patent to somebody else, then the assignee can actually file the infringement suit and they can get the benefit out of it. I don't. Okay. And that is why now I am in Arizona State University. If I invent something in the US, I am the inventor and I am the assignee of that particular invention. Um, Rather, I am the owner of that particular invention. But when I am doing that particular invention in the premises of Arizona State University, I make ASU as an assignee of that particular invention. And in return, ASU is giving infrastructure, space, money to do that. Okay. Now, when I'm considering any company like Reliance, suppose there is a research and development section, they are performing any kind of inventions, they become inventors of that invention. They do not become owner because ultimately they are going to assign that particular invention to Reliance Industries, and Reliance Industry in return gives them salaries to do that particular invention. Okay, and that is why this particular section is very important, that the true or first inventor can get the patent or the assignee or legal representative of the deceased person. So you understand the difference between assignment and licensing. Yeah. Third way of transferring the right is relinquishment. नहीं चाहिए. I give up on that right. That is relinquishment. Fourth way is testamentary disposition. मतलब मैंने मेरे पास right है and then I give it to my children. That means हम लोग जो will लिखते हैं, that is called as testamentary disposition. And the last mode is the compulsory licensing. Now, compulsory licensing is another interesting thing, and it is specifically from the Article 31F of the TRIPS agreement. We talk about Doha Declaration. So let's first understand what is compulsory licensing. Let's take this particular example. So Bayer Pharmaceutical is a very big company, and Bayer Pharmaceutical made a drug called as Nexavar, which is a cervical kidney cancer drug. Okay. Now, when Bayer made that particular drug Nexavar, and it was Nexavar was made in the US, so they got US patent. Now they took the same patent, they filed for the same patent in India, and they got into the market and they started selling the drug. Now they when they started selling the drug, which was 2.8 lakh rupees for the supply of 1 month. Now the thing is, kidney cancer सिर्फ अमीर लोगों को नहीं होता, it can happen to anyone, right? So there was no affordability to that particular medication. So क्या हुआ? Natco, which is a generic company to India, what they said is they asked Bayer that please license your drug to us and we will make that particular drug in lower cost. So they said कि हम लोग 8,880 में बनाएंगे 120 टैबलेट एक महीने का सप्लाई. Now consider 2.8 lakhs and 8,880 rupees. That was the difference back in 2008. Bayer said no, we cannot do that because that is our way of earning money. So what did NATCO do is NATCO applied or NATCO brought government into picture. Why? Because in this particular case, Bayer is filing the patent, so Bayer is the patentee. Who is giving patent rights to Bayer in India is the government of India. So he becomes second party, and NATCO becomes the third party. Now NATCO told government that we will make the next hour at the lower price. Again, there is a difference between net sale and gross sale. So net sales. Again, there is a difference between net sale and gross sale. So net sales, they will pay 6% royalty to Bayer Pharmaceuticals. So that is why it is not a normal licensing. So if Bayer would have given that particular license to NATCO, it is called as normal licensing. If government intervenes and make it compulsory for Bayer to give that particular patent to NATCO, then that is called as compulsory licensing. Now this is for distributing these drugs within Indian territory. According to Doha Declaration and Article 31F of TRIPS Agreement, you can actually go for compulsory licensing to distribute drugs to the underdeveloped countries. That means if NATCO would have said कि मुझे नाइजेरिया में ये drug भेजना है, because they do not have enough infrastructure to do that, then Indian government can make Bayer to compulsorily license that particular drug to NATCO so that NATCO can make that drug at a lower price and export it out to Nigeria and sell it there. Okay, so that comes under Doha Declaration. It's a very interesting part of compulsory licensing. Did you understand this? No problem, right? Why I'm doing it fast? Because I have only 7 minutes to finish. Um, let's quickly go over different parts of patent. So, like your research paper, there is title, bibliography, invention, object of invention, so on and so forth statement. A very important part of a patent document is a claim. So, understand why claims are important. So, whenever I claim it, I always start with we claim and a semicolon. This is how the patent document is written. Okay. Now, see that the first मला चार्जर दे ना चार्जिंग वायर समोर मोबाईल the first claim we say that a golf bag security system for detecting. So this is a kind of preamble. Okay, preamble matlab a preview or what you can say prastavna, what we call that is a preamble. So when I say a golf bag security system, and then I write multiple things about it, comprising, this is the transition term. Okay. When I say comprising of, it is a close ended term. So when I say an invention is comprised of A, B, C, D, that means it has only A, B, C, D. It doesn't have anything else. Okay. If I say that includes, that means it, if the invention includes A, B, C, D, that means it has A, B, C, D for sure. But apart from A, B, C, D, there might be E, F, G, H. So those are called as open-ended transition terms. Can you see me, right? Am I audible?
Yes, sir.
Yes. Can you hear me?
Yeah, yeah. Yes, sir.
Okay. So the first part to the patent becomes a preamble and then the transition term. Transition term can be open-ended or close-ended, and that is very important because if you are using close-ended terms, you are restricting your patent. If you are using open-ended terms, then your patent scope increases. Okay, and then comes a body of patent. Okay, so this first patent is an independent patent. It is not dependent on anything. Now, when I write in the second part of the claim that the system defined in claim one, that means this second claim is dependent on first claim. So that becomes a dependent patent, the dependent claim. So understand the difference between what is independent claim and dependent claim. The two types of claims. So you can have multiple such claims. Okay, so this is the patent which I got. This is something my patent, so you can see my name. So what is claimed is the one of another way of writing the patent, and where they start with these things. So these are different parts of it. Another important thing to understand that when your patent is granted, you get B1. If your patent is not granted, it is in the initial phase of application, you get A1. Okay, so I have these are the two patents. So understand the parts of patents, and claims are very important. And there are different types of claims. Let's not get into that discussion. And there is patent classification. So I think Lingaraj, you asked me about how to find out different types of claims. So all the patents are, whenever you see, you can see this particular type of classification, which is under WIPO. So there are 8 different classes of patent, and you can actually have subclasses of that. So this is how the patent classification works. And there are different ways in which you can actually search for different types of patents. Okay, and this is another. So patent search is a very big copyright. Okay, so understand this statement. Patent search is a very big copyright. So there are different types of softwares which are copyrighted softwares for patent search. Okay, I mentioned earlier that how to file patent in India. So first you file a provisional patent. Within 12 months, you file a complete patent, and then you can file for refiling before first publication. Now the gap between filing and refiling is around 15 months or less than 15 months. And then what happens is the publication of the patent, which is very, very important. Now this provisional patent and a complete patent are now published. They are now open in the public. Now, why this particular publications are without a publicized, so that people can say whether this particular patent has already been patented in another country, or is it a prior art or no. So this particular publication is international. Okay, under section 11 and 12. Once it is published within 18 months of the filing of provisional patent, then it goes through first examination. Now it is a deferred examination system, मतलब तुम्हें पैसे देने हैं कि हमारा पेटेंट एग्जामिन करो. Okay, so that is the first form 18 that you have to sign. And after the first examination report is out and all the objections are cleared, you get a grant. Your patent is granted. Now, from the date of publication till the grant of patent, if any other company or any other patent holder from any other place, if they oppose your patent, then that is called as a pre-grant opposition. After the grant of patent, if somebody comes within 12 months and say no, ये हमारा patent था पहले, then it is called as post grant opposition. If that post grant opposition is granted, your patent is revoked. If it is not granted, if you get the patent, then you get the patent. Your patent is granted. Okay, so if opposition is granted, you revoke. If the patent is granted, you get the patent. Okay, now important, the most important part is the filing of provisional application. When you file your provisional application, the date of filing, the time at which you file, everything is written in that particular application, and that date becomes your priority date. Any kind of invention in the entire world after that date, if somebody is doing the same thing as yours, and if they file the patent, you can say that I had already filed this particular patent in India, so you do not have any priority over that. So you can enjoy that particular priority from 20 years starting from the priority date. Okay, got it right? So this is how the patent filing happens. It is a very simplified view of patent filing. So this is how the patent filing happens in India. Okay, no problem. Now there are different types of patent. The one which I said is called as ordinary patent application. नॉर्मल जिस तरह से होता है. Now there is convention patent application. So why it is convention? Because we spoke about Paris Convention earlier. So countries which are signatories to the Paris Convention. So US is signatory to Paris Convention. India is signatory to Paris Convention. So when I file a patent in India, after my pro complete application has been filed in India and now it is getting into the first examination, at the same time I can file that particular patent in the US. Survey or examination for the global patents in different countries, and then they give you a report. In India, when you file for the first examination report, it is considering for Indian patent activity. This particular PCT application is for the global, and once you get that particular examination report, you can tell PCT that now take my patent and apply it in the US, Norway, South Africa, Australia, and different countries. So through PCT, you can apply your patent in different countries instead of you going through convention patent application directly. Okay, so this is the main difference between PCT application. I'll talk about it. Then there is patent of addition. मतलब मेरा already एक patent है and I add some more thing on that particular patent. Okay, so that becomes patent of addition. Why patent of addition is important? I can increase the scope of patent, but I cannot increase the date. I get the same priority date. मतलब मैंने 1 जनवरी 2025 को कोई पेटेंट फाइल किया है. I add something to it on May 1st 2025. So that becomes patent of addition, but this patent of addition gets the priority date of 1st January 2025. That is a patent of addition. What is a divisional patent? When I file something on 1st January 2025, office says that these two inventions can be separated from each other. So file this separately. So one invention I filed on 1st January 2025, and a part of that invention which I separated, I filed it on February 1st, 2025. Now they do not get the same priority date, but my first patent will get over on 1st January 2045, and my divisional patent will get over on 1st February 2045, 20 years after this particular patent. So that is a divisional patent. Okay, like our ordinary patent timeline, you have PCT timeline also to apply into multiple countries. Okay, so that is how the IPR protects the patent protection works. There are other related acts like Plant Variety Protection and Farmers Right Act, geographical indication, traditional knowledge, cyber security, other IPR acts like copyright, trademark, industrial design, and circuit design, and so on. Okay. I already spoke about the enforcement system, like the judiciary system, Indian Patent Office and IPAB we have. We have Intellectual Property Appellate Board, High Court, Supreme Court, District Court, the same way. I also spoke about Section 48. I spoke about the de minimis principle with you. And again, it goes by the same civil and criminal remedies. Yeah. So I think that's it. It is too much to have these things in one lecture. So yeah, I'm done over here. If you have any questions, please feel free to ask.
Anyone have doubts, please ask to sir. Sir, just to elaborate because maximum here audience are the students. Could you please elaborate that what's the it's where difference between the patent and the corporates? It's which one to be registered in copyright and which one to be go for patent?
The first important thing is you cannot get the patent unless you register it. Copyrights do not need registration. That is the first difference between them. Copyright, um, so copyright is given when your idea is original. Okay. Patent is given when your idea is executed and it is novel. The criteria of novelty is not there in copyright. It is there in patent. Okay. For example, mm, you have seen movie. I don't know. Probably. You have seen movie Dawn, right?
Yes.
देखिए नहीं देखिए. Yeah.
Yeah.
So the first Dawn movie was Amitabh Bachchan ka Dawn movie. The second Dawn movie was Shah Rukh Khan ka Dawn movie. The script was almost overlapping, but considering the cinematography, the casting, and everything, both the movies have their own separate copyrights. Okay, so that is how the originality works. Okay, but when it comes to patenting, I am designing a car which looks like Tesla, then that is not novel. Tesla will file a suit against me. Oh no, I stopped this. Stop sharing the PPT. Somebody said PPT is not visible. I stopped sharing it. Okay, got it. The main difference between copyright and trademark. These 2 points. First is copyright is given on originality. Novelty is not necessary. Patent is given for novelty. Copyright registration is not mandatory. When you write, you get the copyright, and that is why when you write papers, एग्जाम में व्हेन यू राइट पेपर्स एंड हम लोग मतलब जो कोई भी झुक के दूसरे का पेपर देखते इट इज वी से दैट ही इज कॉपिंग मी. So you are actually infringing somebody else's copyright. You are not going anywhere to register that thing, right? So that is how the copyright works. For patent, if you are watching somebody else's patent, you have to actually implement and say, unless and until then, you are not infringing somebody else's right. That is how the difference between copyrights and trade. Copyright is really interesting because my specialization, my project, my thesis was on copyright. Patent is very simple act. Copyright is very difficult act because there is no need of registration. That is another difference.
Yes. Thank you, sir. Anybody having any doubts? Sir, my personal questions are there. If you don't mind, is it okay for you?
No, no, say tell me, I'm already hungry.
Just last question. Okay, then. Is it for the registration of the patent advocate or something? Any registered organization is required to go for patent?
So for patent registration, you need patent agent. So in India, we have separate exam for patent agents. So you have to give that particular exam. And the main requirement is you have to be science graduate, BSc. I don't know if there is any change in the that mandate, but you have to be a science graduate to give the exam for patent agent. But people who are, I mean, in code, that's a different story. But to be a patent agent, you have to be science graduate and you have to give a separate exam for that.
So thank you so much. I think so. No one is sending any message here. Thank you so much, sir, for your patient response for our questions. Sir has covered the history of IPR
Your
and
questions were really nice because I might have missed on certain aspects. I don't know. So you actually helped me cover those.
thank you, sir. Thank you. Sir has explained about the history of. Yeah, sir. Yeah, please. Sorry, sorry.
No, go ahead, go ahead, go ahead.
Sir has covered the history of IPR and even explained about some of the baseline organizations, so through which all the patents all over the world, the countries are working. And sir has explained about transfer of rights and the parts of patent and how to claim it, and even the parts of the patent. So thank you so much for your wonderful session. So really, it was honored to for this function, sir. Thank you so much, sir.
Thank you so much to all of you, especially Ria, for asking me. Hope she is there in the session.
Yeah, yeah.
Yeah. Thank you so much for coming.
I will talk to you later. Okay,
Yeah.
see ya. Bye bye.
Thank you, sir. Thank you, sir. Bye, sir.
Yeah.
So now I would like to move to the second session. So before that, I just would like to give an information regarding Dr. Srividya Ravi Madam. Srividya Ravi Madam has been in the field of intellectual property rights for the almost 20 years after spending about a decade in the pharmaceutical industry. In the field of pharmaceuticals, she has been in the product development, quality assurance functions. She is currently at the Pune operations of Gnanlex, a more than 20-year-old Indian law firm for devoted to IPRs. She was handling a crucial inventor facing a role at the CSIR NCL Pune amongst other clients, and has experience in handling patients in the field of chemistry, pharmaceuticals, fine chemicals, food and nutritional products. Extending her interest in IPR, she recently completed a 5-day online training programs on essentials of tech transfer. She also served as an consulting editor to the Indian Drugs, the official journal of Indian Drug Manufacturers Association. Sri Vidya Madam has a doctoral degree in health sciences, a master's in pharmaceutical sciences, with a PG diploma in patients law and a patent agent. Combining her educational background and rich experience in the pharmaceutical industry with her knowledge and exposure to IPRs, Sri Vidya ಈಗ ನಾನು ಏನು ಹೇಳಿ ಮಧ್ಯಕ್ಕೆ Srividya, sorry for the interruption. Srividya is a resource person for the pharmaceutical regulatory sciences as well as the IPRs. She is a speaker at various workshops, seminars, and training sessions at national as well as the international levels. She has been involved in the training of pharmaceutical and chemical patent examiners for the various countries such as India, Indonesia, Egypt. Because of such technical problems, Madam is facing certain issues in login. Kindly, all the participants cooperate with us. Maybe it takes another 2 minutes to her to get inside. So once she entered, we'll begin the session. So be patient and cooperate with us, please. Okay. One minute. ಅವ್ರೇನಂದ್ರೆ ಕಾಲ್ ಮಾಡಿದಾಗ ಜಾಯಿನ್ ಆಗೋದಾರೆ ಅದೆಲ್ಲ ಅವ್ರಿಗೆ ಇಂಟ್ರೊಡಕ್ಷನ್ಸ್ ಎಲ್ಲ ಸ್ವಲ್ಪ ವೇಟ್ ಮಾಡ್ತಾರೆ ಅಥವಾ ಟೆಕ್ನಾಲಜೀಸ್ ಎಲ್ಲ ಬಂದ್ಮೇಲೆ ಇದನ್ನ ಮಾಡಿ ಬ್ರೀಫ್ ಮಾಡೋದು ಬಿಡೋದಕ್ಕೇನಿದೆ ಅವ್ರ ಜೊತೆ ಯಾರು ಕೋರ್ಡಿನೇಟ್ ಮಾಡ್ತಾರೆ ಸರಿಗ ಹೋಗಿ ಹೇಳಿದ್ರೆ ಮತ್ತೆ ಅವ್ನು ಕೊಂಡಾಗ್ತಾನೆ ಹೇಳ್ತೀನಿ ये आके यहाँ पे बोलते पहले उसको बोलना मैं उसको डांटूंगा नहीं वो डांटेगा ना क्या हुआ मैडम थोड़ा लॉगिन करने में टाइम लग रहा है तब तक तुम पॉज कर सकते हो क्या यूट्यूब का नहीं पॉज नहीं होता हाँ हाँ मैडम हो गया लॉगिन नहीं कैसे पता चलेगा धनंजय ये देखते रहना है ना ये कौन मैडम का नाम क्या है श्री विद्या Yes, sir.
श्री विद्या
विद्या रवि रवि टाइप करा RAVI मुझे अर्जेंट सुसु के लिए अर्जेंट हुआ है
नर्सिंग फाउंडेशन से लैब से कुछ आर्टिकल चाहिए
कशाला
एप्लीकेशन देना पड़ेगा पहले
बरोबर
Hello, we are waiting for our next speaker to join in. She will be joining in next 2 minutes.
madam very good morning ma'am
Good morning.
madam I'm Dr. Lingaraju here
Joining.
yeah very pleased to meet you madam shall we begin
Yeah, I'm good to start.
yeah just give me a minute I'll just give a brief information about you to the audience
Certainly, sir. Please take your time.
yeah thank you so much ma'am Dr. Sri Vidya Ravi madam has been in the field of intellectual property rights for almost 20 years after spending about a decade in the pharmaceutical industry. In the field of pharmaceuticals, she has been in the product development and quality assurance functions. She currently heads in Pune operations of Gnanlex, a more than 20-year-old Indian law firm devoted to the IPRs. She was handling a crucial inventor facing a role at the CSIR NCL Pune among its other clients and has experience in handling patents in the field of chemistry, pharmaceuticals, fine chemicals, food and nutrition products. Extending her interest in IPRs, she recently completed a 5-day online training program on essentials of tech transfer. She also served as an consulting editor to the Indian Drugs, the official journal of Indian Drug Manufacturers Association. Srividya Madam is a doctoral in health sciences, a master's in pharmaceutical sciences with a PG diploma in patents law, and she is a patent agent. Combining her educational background and rich experience in pharmaceutical industry with her knowledge and exposure to IPRs. Madam is a resource person for both pharmaceutical regulatory sciences as well as IPRs. She is a speaker at various workshops, seminars, and training sessions at national as well as international levels. She has been involved in the training of pharmaceuticals and the chemical patent examiners for various countries such as India, Indonesia, Egypt, Vietnam, Malaysia, African nations, and few other South Asian as well as American countries. And she is one of the recognized consultant to the WHO to set up the COVID technologies database. This is a short, brief information about the madam. Madam, thank you so much for being here. Really, we are looking forward from you regarding the how to do the patent filling and what all the required forms and the formats and what all the basic means. Suppose I want to register for a patent. What is there any qualification required? Is there anything specifically required? Then only I can apply. Or like this, many people have doubts, and you know that we are belongs to the nursing fields. I know that in the pharmaceuticals, a lot of patents are registered. Really, when during COVID-19, I come to know about that. So really,
Right.
please, if you give an information regarding, because we are a nursing field. In the nursing field, how can we do some of the researches that we can be registered in the patents and all? If you give that information, that will be very grateful to us now.
Right.
Thank you so much and
Sure.
welcome.
Yeah. Yeah. Thank you. Thank you for the warm introduction. And yes, I will try to, make ensure that you spend the next, 90 minutes or so learning about various aspects of patenting. Intellectual property rights today has gained a lot of importance independent of the field you're working in. There was a time when the pharmaceuticals was one of the most important or critical field where patent protection was very much desired. However, today you're looking at a scenario with the government encouraging so much in terms of entrepreneurship and startup ecosystem emerging, with all educational institutes being extremely involved as well as collaborating with the industry. IPR has gained a tremendous recognition, and its importance has been understood by each and every uh, field of science as well as engineering. So you see more patents being filed by automobile manufacturers, more patents being filed by electronics domain people, as well as medical, devices, which has emerged in a big way post COVID scenarios. So I am of course going to elaborate on the various forms and formats. Initially, one of my slides is giving a very detailed explanation on how patent filing process itself progresses. Okay, particularly I'm focusing on the Indian patent. If you have any particular queries regarding international patenting or how the procedure flows there, I'll be happy to answer those doubts. At the outset, let me tell you, forms and fees and formats and all um, can be a little boring for nurses. You people are known to be on your feet. You have a very dynamic work atmosphere, and if I go on elaborating on what each form contains and how much fee you have to pay for each of those processes, it can end up a little monotonous. However, I have slides where I have case examples. We have a case study with regard to one of the problems that you as nurses face in your daily professional life. So we'll discuss that case in detail so that you understand what is the demand on you if you are an innovator. And a second, caution I would like to throw to you is I would, encourage you to be more interactive in this talk. Please feel free to unmute yourself, ask questions. Okay, if there is a concept you want elaboration, please let me know about it. And if you don't want to do it in between and you want to leave the questions in the chat box, that is also fine. I'll try and take it up at the end of the session. But interaction will certainly help because otherwise you're only just listening to someone And particularly, when you're looking at forms and all that, it may become a little monotonous. But when you're looking at patentability criteria, as Sir pointed out, what qualifies an invention to be patent protected? That qualification, the criteria that have to be satisfied, the demands that you as an innovator have to fulfill, those aspects we'll try and highlight. And please feel free to come up with your queries at that point of time. So, with that, I request you to allow me to share my screen. I will. I have multiple documents which I'll be using through the presentation. So I'll continuously be switching from one set of documents to another. Please bear with me for that. Only reason being there are quite a number of forms and formats, so I didn't want to crowd all of it inside a presentation. That is the reason there will be multiple documents plus the case study. Of course, I want to show you a live patent, so what goes into a patent, what are the contents. So therefore, I'll be showing you something that has already been filed and put into public domain. Okay, so with this, I'll start the art of patent filing. I also take this opportunity to thank this Sunanda Praveen Gambhir College of Nursing, Madam Principal, and the staff for inviting my team, Nyamlix, and me in particular to present this session. And I look forward to also interacting with the MES College at Ratnagiri and their faculty members and students, if any. And congratulate you on this conference on innovation and impact, exploring IPRs and research grant opportunities. So, launching on to what qualify as the features of a patent. So we'll just try and understand some basic concepts on what a patent is. Okay, a patent is a territorial right, basically, okay, granted to inventions. So, territorial means your rights are limited to the country where you have applied and you have been granted patent protection for your invention. Okay, so if you have if you have an Indian patent, okay, you can enforce it only in India. If you have a US patent, only in okay. Can I request everyone to mute, please? Thanks. If you have a US patent, okay, that is the only country where your rights will be enforceable. Similarly, in other countries, a Japanese, a Chinese, your patent rights are enforceable only within the geographical limits or the territory of that particular country. Okay, so in short, what this translates to is where you want patent rights, you have to go and file a patent application for the invention in that country and get it granted there. Okay, so that is what territorial rights means. And what exactly are the rights? It's a negative right, as the law suggests. And the rights are, you can prevent others from manufacturing, offering for sale, using, selling, or importing your invention. Okay, your invention cannot be used by anybody other than you. You can, of course, grant a license or grant permission to others to use your invention or use your patented technology. Otherwise, you can prevent others from doing these five activities, that is shortened as MOUSI: manufacturing, offering for sale, using, selling, or importing the invention. Okay, so if you are not able to commercialize your invention, you have made a very good innovation, you have applied for a patent, you've got a patent granted, but you are not able to commercialize it for whatever reasons. Maybe you love to do research, so you've gone back to the laboratory, or maybe you don't want to get into the large scale manufacturing, marketing, getting the regulatory approvals. You don't want to get into all of that, so you can license it to a third party, and then they will take the patented technology ahead. So in the meanwhile, nobody can do any commercial activities with your invention. So that is what is a patent right all about. So it is granted to an invention It is enforceable within a country. You have these five rights. Now, for the rights that is given by the law or by the country to you also have some obligations or duties. Okay, so patent right, like any other right, is a balance of duties and rights. Okay, this is how our Indian constitution itself is framed. We as citizens of this country have certain rights: right to education, right to live in anywhere in the country, right to travel across the country, right to pursue any profession that you want to. You have all these rights, okay, but you also have some duties. For example, you need to pay your taxes on time. You need to abide by the other laws that are enacted by the country. Those are your duties. Similarly, in the patent law also, while you have a right to exclude others from exercising the rights of manufacturing, offering for sale, using, support, selling or importing the invention, it is your duty to disclose the invention to the patent office while applying for the patent. Okay, so in short, a patent is a disclosure of the invention. Like a publication, a patent is also a disclosure. What you disclose, you can seek protection only for that. Okay, you cannot go beyond what you have disclosed. Therefore, remember, if you want to maintain something as a secret, okay, you don't want it to go into public domain, you don't want anybody to read about your invention and practice it, then you should maintain it as a confidential information. If you disclose, or if you file for a patent, then disclosure is mandatory. Only what is disclosed can be protected. Okay, and the right that you get is enforceable for 20 years from the date of file. Okay, and who are these various people involved in this entire process? So who are the people you will come across who will grant you these rights or help you in getting the rights and enforcing it as well as commercializing it? So you, of course, is the most important stakeholder. You are the inventor, you are the person who has worked in the laboratory, you have conducted the experiments, you have the results, you have determined that you have come up with something that is path breaking, right? So you are the inventor. The individual who has exercised his or her intellectual capability to invent something or to solve a problem or to overcome an issue. Such an individual is an inventor. So inventors are always individuals. Okay. Now who is an applicant? Okay. The individual can be the applicant of the patent. So he can apply for the patent himself. Or if you're working somewhere, then your organization will be the applicant. Okay, suppose I am working in company X, okay, and I do some innovations there, and company X decides to file for a patent. Then I will be the inventor, but company X will be the applicant. Now, who owns the rights? The applicant owns the rights. Okay, the rights are with the applicant. Then what does the inventor get out of innovating? Okay, typically, if you're working in a commercial organization like a corporate or a company, okay, then during your appointment itself, they'll tell you that whatever innovations you do, the ownership will be with the organization. However, if you're in an academic setup or you're in a research institution, then there can be a different arrangement. Okay, they may say that you can apply, but the rights have to be transferred to the research organization. Or they say the institute will apply, but when the commercialization occurs, you will get 40% of the share of the profits. So there will be some such arrangement. Okay, so the applicant can either be an individual or it can be a non person. It can be a corporate or an education institution or a small or medium sized company or a startup. It can be a hospital, it can be a trust, it can be a university, it can be any of these entities. Okay, so an applicant can be either an individual or a non individual, but the inventor will always be an individual. Okay, it is the intellectual capability of the individual out of which the invention has come out, and he will always be acknowledged wherever he is, whether in the corporate or in the education institute, the intellect will always be recognized as the inventor. Okay. Now, the patent office, of course, is an important stakeholder because you have to apply for the patent protection to the patent office. They will, look at the patent to see whether it is eligible to be granted. And then you will have a series of correspondence with them. And eventually, it will either get registered in your name or it may be rejected for whatever reason. So, they are a very important stakeholder and they are the people who are ensuring that the Patent Act is being followed. Okay. The government is an important stakeholder because they are evolving the laws. Okay. They are providing the facilities for the patent office to function as an enforcer of the Patent Act. Okay. Now, if you are licensing your technology, the person who is licensing, okay, the licensor, as well as a person who is receiving the license, is either getting the rights assigned to him or getting the rights licensed to him. They are important stakeholders. And finally, of course, the judicial system. Because if there is a conflict, if two people do not agree, and there is a litigation or there is a court case, as we may say, okay, then it is the judicial system who will ensure that justice has been delivered to either of the parties. Okay, so these are the important stakeholders. Of course, there are international offices. There are international patent offices as well as organizations like UN type of body, which is called the World Intellectual Property Organization, and then a series of treaties to which India is also a signatory, and those also become important stakeholders when you go on a global basis. Okay, we are currently looking more at an Indian scenario. All right, so moving on further, um, can somebody just confirm that the slide has transitioned to the next one? Just in case, because sometimes there are problems.
No problem. It's fine.
Yeah, you can see it. All right. Okay. Thank you so much. All right. So, as I said earlier, as an individual or as a citizen of India, you can seek patent rights in India, of course, and you can also seek it in any other country in the world. Okay. So, you have to abide by that particular country's patent laws, but you, as a citizen of India, can seek patent rights in any country of the world globally. Similarly, citizens of other nations can seek patent rights in our country. Okay. Now, each country has its own laws. Okay. There will be certain differences. Okay. They will have their own forms, own fee structures. Okay. However, by and large, I say the law, the forms, and the procedures are harmonized globally. Okay. To a large extent, you will find the same process being done in most countries in the world. There may be slight changes here and there, but you can assume that it will almost be similar in most countries in the world. This is because most countries have signed, multilateral treaties and they abide by. Okay. Now, particularly if you look at the Indian Patent Act, there are about 31 forms, okay, under the Patents Act. We'll look at each of them shortly, of course. And if you're looking at the Patent Office itself, which enacts these laws and forms and fees and everything, they work under the Controller General of Patents, Trademarks, and Design. And they have offices in all the four metro cities, that is Mumbai, Delhi, Calcutta, and Chennai. Okay. The patent office in India is highly, I would say, a modern patent office with its website being very interactive and very active. Okay, all resources are available online. The format of the forms, the gateway to make the fee payment, the fee structure, the actual act and other publications of the patent office, and the references that you have to make for already filed patents, or if you want to find out the status of your application, if you want to find out whether it has been granted, if you want to find out if there is a correspondence issued by the patent office, all that can be looked at just sitting at your desk. Okay, I've given the link below. IP India or the Intellectual Property India, Government of India Patent Office. This is a link to the home, other intellectual property at this form. So they're in charge for all of that. This particular link will lead you to the particularly the patent office, but you may look at other things. There is design, there is geographical indication registry, and so on and so forth. Okay. And typically, when people apply for patents, they either employ a patent agent, someone like me, or a patent attorney. Okay, a patent attorney is a person who knows the patent law but is also an lawyer. Okay, so while I'm not a lawyer, I am more a scientist. I'm not a lawyer, but I am a patent agent. I understand the patent laws, but I don't do legal practice. Okay. However, if you as an inventor decide that you want to file the patent by yourself, that is also possible. Okay. The patent office does not say that you necessarily need to have an agent or an attorney. Now, why do you need an agent or an attorney? Because at the end of the day, the patent is a joint document from the technical side as well as from the legal side. Okay, it is what is called a techno legal document. Okay, the invention is always with regard to a field of science or technology. Okay, so inventions are typically from any area of science or technology. So there is a heavy emphasis on understanding inventions from a technological perspective. However, since you're applying for a patent protection, you need to abide by the patent law or the Patent Act. So there is a legal aspect as well for it. And if you're looking at yourself as an inventor, then you understand your invention, you understand your technology, you understand the science behind it very well. However, you don't understand the legal part of it. That is why there are specialist patent agents or there are specialist patent attorneys. And taking their help is advisable because you're talking about your rights and you're talking about holding on to those rights and enforcing those rights for 20 years. Okay, that's not a very short period. So if you commit any error initially because you were not aware of how to do certain things, then you have to carry it forward and abide by it for the next 20 years. Okay, you may end up losing something very valuable, or you may end up overseeing something that is very critical. Therefore, it is always advisable to take the help of an agent or an attorney. Okay. However, it's not uncommon for inventors to do on their own for various reasons. Of course, one of them being funds. But I see that your conference is on also getting grants, and I just take a minute here and say that even to get grants to filing IPR, there were several schemes from the government of India. Okay, your patent filing can be entirely funded by the government. Your foreign filings can also be funded by the government. And it is not only the central government which is providing these kind of schemes. There are state governments also. Maharashtra government is in fact quite prolific. So also few other state governments. And in case you have already filed for a patent and you think you've spent a lot of money, then the good news is Maharashtra government even has a refund scheme. Okay, so you can apply on the into that scheme, and for whatever expenses you have incurred till date to protect your invention through a patent application, the government will refund you that money. Okay, so there are various schemes. Please be aware of them, read about them, and ensure that you leverage all of them to your advantage so that you can secure your inventions and innovations through the patent filings. Okay, so moving on further, I'm going to give you a little elaborate description of the patent grant procedure in India, after which we'll go into the specific forms and fees. Okay, so starting off at the top left of the screen, okay, what I put down here is what is called prior art search. Okay, now what is the prior art? A prior art is any document or any you know text material that is available in the public domain before the date of your patent application. Okay, so suppose today is your date of invention. Okay, let's assume 25th July. Okay, and any document that's come up in the public domain. Okay, it could be a journal publication, it could be another patent, it could be a newspaper article, it could be a thesis from a dissertation or a PhD thesis from a student. Okay, it could be a blog written by somebody. It could be an abstract submitted for a conference. It could be any of this which is available publicly. That is, you, me, all of us can access it, maybe through a library, maybe through some online resources. It can be any of these. Okay. So any such document is called a prior art. Okay. Now, why do you do a prior art search before you file for a patent application? Is because you want to find out if any document in the public domain, okay, discloses something that is same or similar to your invention. Okay. Now, what is the demand of the patent office? They say invention means it should be something new. It should be not at all known to anybody in the world. Only such a technology or such a innovation, okay, a product or a new product or a new process, okay, can qualify for a patent protection. Okay, so you will look at prior arts prior to the date of application and see if there is nothing that is similar that is disclosed by anybody else in the world. Okay, you will determine that, and then if there is no such document, then you'll go ahead and file for the patent application. Okay, now while filing for the patent application, you have the option to file what is called a provisional application or the complete application. Now, what is the difference between these two? The difference between these two is, consider you're working in some particular field of science, okay, and you have to do a lot of technological work. You also have to collaborate with someone, okay, with an external party. Now, suppose you have made the basic invention, okay. Let us assume that you're making a new hospital bed. Okay, it is an invention that is very close to your field of work, right? You have innovated something around a hospital bed. A hospital bed is a very well-known product, right? Now, not every invention, let me tell you, is absolutely new and not known at all. Okay, there are innovations that are also incremental. That means the basic technology is known, but you're going on making inventions to improve that technology. Okay, this is very common, right? Let me give you the example of an automobile. Okay, once you make, say, this electric vehicles that we are seeing, once the basic electric vehicle was made, that was a path breaking or a radical invention. But after it was made, there is continuous improvements to give better mileage, to include more features in the bike. Okay, you're seeing all of that. 10 years back we didn't find good e-bikes. Today there are so many good e-bikes, right? 10 years back we were seeing more of only e-scooties. Today there are even e-auto rickshaws, e-buses, e-automobiles, so many of it, which means there is so much of advances in the battery technology. Okay, just look at your cell phone. Okay, 10 years back you had to kind of charge the battery more often, or you took longer to charge the battery. Today that is not the case. Even within an hour or maybe even less, you have your cell phone battery charged, and it runs the whole day independent of the number of apps you keep open, right? So these are what are called incremental technology. Okay, the basic science or technology is known, and then somebody goes on improving it. Somebody goes on making more advances, and those advances are also eligible for patent protection. Okay, it's not only the path breaking ones, it's also the incremental ones which are eligible for protection. Okay, so suppose you're working on some such incremental technology and to test it, your hospital bed, for example. Okay, and to test that particular hospital bed, okay, you want to fabricate it. So you want to collaborate with a fabricant, a party which fabricates hospital beds. Now you have to disclose to him what is the improvement you have made so that he fabricates it accordingly. But you have the fear that he may take that away and file a patent application on his own. This is very common, let me tell you, that if you disclose an invention to any person without securing it through a patent application yourself, then you're exposing yourself to intellectual theft. Okay, anybody can borrow the idea and file a patent application on their own. So what do you do under these circumstances? You file a provisional patent application. So your invention is not completed. You have a broad idea, you think a mechanism that you're proposing for the bed will work, but you have to go to the fabricator, get the bed fabricated, and then test it. And then only you'll have the final results. So, what do you do under these circumstances? The basic design that you thought of, okay, which you expect will work, you have some idea as to, on a very small scale, you've done some kind of laboratory work and you know that it will work. Okay. However, you've not done it on an actual hospital bed. So, whatever small scale result you have got, on the basis of that, you will file a provisional patent application. Okay. The day you file it, the date of filing is in your name as the inventor and your college's name as the applicant of the patent. So, your name and your date is secure. Now you can go and collaborate easily. Suppose your student has to submit a paper to some conference or to some journal, even that can be done easily because your basic idea and the possibility of data that will work, okay, is already disclosed in that provisional application. So the provisional is when work is in progress, the basic idea is validated through some small studies, okay, and you know your invention will work. However, you don't have the entire set of data. Now, how long do you get to complete to your experiments and generate all the data? You get 12 months. Okay. So the date of complete application of the patent from the date of provisional is 12 months. Okay. So while filing a patent application, you need to determine whether you want to file a provisional or a complete. If you have finished all your work, you can go directly to file a complete patent application. But within 12 months, if you don't file provisional to complete, then your case will be deemed to be abandoned by you. Okay. Now, what happens after the complete filing 12 months down the line? Okay. At the 18 months date, the patent office will publish your patent application. Okay. As I told you, a patent is a disclosure. Okay. Now, why does a patent get published? Because this is a mandatory step in the process of a patent application. Okay. And the second thing is patents are brought into public domain for the progress of science and technology. Okay. So I will read your innovation and I will try to conduct even more innovations. Okay. I cannot commercialize it without your permission because you have rights on the commercialization. However, I can conduct research and I can contribute to the progress of science. For that reason, patents are published. Okay. While as a researcher, I cannot commercialize, I can certainly conduct research. And for my research, you cannot say that I am copying your technology. Okay. That is not allowed in the law itself. The law encourages research, but the law discourages commercialization of someone's research without their permission. Okay, so that is the status. That is why the patent application is published. If you want to fast track and not wait for 18 months, you can opt for what is called early publication, and within a month or two, the patent will get published. Okay. Now, once the patent is published at an earlier date or at 18 months, then it is your duty as inventor or applicant to request the patent office to examine your application. Okay. The patent office has to examine your application. Now, what is the meaning of examination? Like all of us go through various exams and tests, this is also a similar process. So, you have patent examiners in the patent office. They will look at your patent application. Okay. They will read it. They will find out, you know, doing their own prior art search, they will find out whether your patent application is eligible for patent protection. Okay, so they will conduct a process of examination and they will issue what is called a examination report. FER means first examination report. Sometimes there is a second one also, which is called an SCR or a second examination report. So the examination examiner issues a first examination report, and sometimes he also demands that you attend a hearing. That means you will go and present your case to the examiner. He will hear you out with regard to the arguments you have to present. Okay, so there can be either a reply to the first examination report, or there can be a hearing. Okay, now what happens before this? Let's understand what happens before you reply to the FER. Okay, now once you have requested for examination, okay, and the patent has been published, in the meanwhile, okay, your patent can be opposed by any person. What do you mean by opposed? Somebody who will file a, you know, representation at the patent office and say that your patent should not be granted for XYZ reasons, which is also within the purview of the patent. Okay, so that is possible. That is a process of ensuring that only valid patents are granted by the patent. Now, if you do not request for examination at all, the patent office will assume that you have withdrawn your application. Okay. So if you did not file a complaint, it gets abandoned. If you do not file for request for examination, then you are withdrawing your application. That is the meaning of it. Now, with regard to fees, okay, you pay fee while filing the patent. Okay, in the first step, provisional and complete. Here there is fee involved, and request for examination has fee involved. Okay, of course, certain other processes also have fee. Like for example, somebody is opposing, there is a fee involved there. Okay, but once you have requested for examination and paid the fee, then there is no further fee for replying to the FER or hearing and so on and deciding by the country. Okay. Now, what comes with the FER? In the FER, the patent examiner may raise some objections to your patent application. Okay, he may say that you have not written something properly, or some figure is not appropriately representing the invention, or something has already known in a prior art, so that part of the invention cannot be granted to you as patent protection. Okay, so he will raise his objections in the FER. And what do you have to do in the reply? In the reply, you can defend yourself. In the reply, you can amend or correct the deficiencies and the objections raised by the examiner. You have the right to do both, defend as well as amend. Amend means to change or modify. Okay, so you can do both and submit your reply to the FER. Okay. Now, like you had 12 months to complete the provisional patent application, and at 18 months, the patent office published your patent application. Similarly, after gap in the time from publication to filing for examination, as well as actual issue of the examination report as well. Okay. So you are looking roughly at a 2 to 3 year process. Okay. So ensure that you select a patent attorney who is stable, okay, who has a long duration of business, and who will ensure that the entire process of patenting, okay, from step one of prior search till decision by the controller, your patent attorney is there throughout the process, hand holding you and ensuring that you are abiding by all the requirements. Okay. Now, what happens when you reply to the FER or you attend the hearing? Okay, either you get a patent granted, okay, and you are given a decision by the controller that your patent is granted. You pay the fee for 20 years. If you don't pay the fee for 20 years, your patent will cease to exist. Okay. You keep paying fee every year. Okay. And then the patent gets renewed through the payment of fee, and your rights are enforceable. Now, like this pre grant representation or opposition, there can be a post grant opposition to the grant of your patent also, which is typically 1 year from the date of grant. Okay. And later, okay, up to 20 years of your patent life, anybody can work on revocation of your rights also, which means they want you to not possess your rights and they want it revoked. Okay. So anybody can, file that kind of a case also. Now, what happens if you do not reply to the FER? Again, your case becomes abandoned. And after the reply to the FER, if the patent office or the patent examiner refuses your patent, you can appeal, you can file a review petition, or you can appeal in the high court. Okay. And if your patent is granted and you're paying the fee and you're commercializing it, then it is your duty to file what is called Form 27. We'll look at what is Form 27 a little later. It basically is a statement which says you are commercially using your patent. Okay. Now, again, here I've shown several forms 1, 2, 18, 18A, 9, and Form 27. We'll look at all of these in detail from some time now. Okay. So, this is with regard to the patent grant procedure. So, you have filing, you have publication, then you have request for examination, then actual examination report, reply to it, then grant or refusal, and in between, you can have a pre grant opposition, later, you can have a post grant session, and there and till the expiry of 20 years you can have revocation, and the decision is always issued by the patent office and the controller general of it, and you can appeal any of the decisions, and you also have an opportunity to make your representation or be heard by the patent office. Okay, so this is how the entire process works. Now, what are the various forms and for what are the forms actually? The forms are for filing, for requesting for examination, to establish who are the inventors, who owns the patent, if somebody is filing oppositions or revocations, if there is a licensing or working maintenance, okay, for various communications that you do with the patent office, okay. If you want to do a foreign filing or apply for a patent elsewhere in other than India, for all such things, there are various forms and fees. Okay. And then this entity who is called a patent agent. Now, who's a patent agent? A patent agent is a graduate in any area of science or technology who has passed the exam conducted by the patent office. Now, to register a person as a patent agent, also there are certain forms and fees. So, the forms, as I told you, we are going to look at, but predominantly with regard to fee. Okay, there are two types of fees. Okay, one for individuals, startups, okay, small entities, and education institutes. Okay, so NP means natural person, SU is startup, SE is small entity. That means you have less than, I think, 100 employees, and education institute is ER. And then you have the others against it. Okay, others are large companies, large corporates, huge research institutes, and so on and so forth. Okay, now the fee for natural person, startup, small entity, and education institute is, I think, one fifth or one fourth of what the others have to pay. Okay, you pay much less. Okay, you have a huge reduction. It is usually 25% or 20% of the fee that others have. Okay, so that is the encouragement given to individual innovators, to education institutes, of course, to startups because they're just starting things, and to small entities who don't have very huge resources. This is the incentive given by the government to encourage you to protect your innovations through patents. Okay. So with this, give me a minute. I'm going to switch to a Word document which shows all the forms and fees, and then we'll come back to this presentation. Okay. Just a minute. All right. Is the document visible to everyone?
Yes, ma'am.
Thank you. Okay. So basically, this is a table. Okay. I would request you to just understand that the following details are there. The form number is there, the section and rule of the Patent Act, which is applicable, the title and the purpose of the form, the fees that have to be paid. Okay, now these are all fees that are to be paid online. Okay, when you're paying in person or when you physically go to the patent office to pay, you have to pay 10% more. Okay, so there is a discount when you pay it online, and we generally now everybody has adopted the online process. That is why I've specified only that. And as you can see in the first one itself, we are looking at a one-fifth rate for natural persons, startups, small entities, and education institutes as against others. So that is how the general fee structure will be throughout the patent. And the timeline when it has to be paid is also specified in this particular table. Okay. So we'll go through these entire forms and fees, and then we'll go back to the presentation. Now I'm not going to go into each and every detail. Okay. And there are certain forms which are not, the most critical of them. Okay. The first set of forms, okay, I have divided them into various categories. And the first set of forms are with regarding filing of a patent and the processes that follow. So these are the most important ones for you from a patent, from an innovator perspective, and the rest of it is for practicing at the patent office. Okay, so we will focus on the first set of forms, but I'll certainly walk you through all the others. Okay. All right. So the first one is your application for a patent. Okay. So you are going to write to the patent office and tell them to grant a patent. Okay. So you will tell them whether it is a provisional or a complete, whether it is an international or a national application. Okay. You will tell you who you are. You will tell them whether you are a now individual, a startup, or any other entity. All the inventors names will be given. Okay, so the patent office expects each and every person who has contributed intellectually to the invention to include all his or her names. Okay, a patent can have any number of inventors, so you have to include everybody who has intellectually contributed. Then you give the title of the invention. You give the agent details if you have any. If you have a patent agent or a patent attorney, you give their details. Okay. Then there are certain other types of patents like patent of addition or divisional patents. If it is so, you give that. Okay. We are not going into those details now. And then the inventor and all the inventors are expected to sign form 1. Okay, you sign saying I am the inventor of this particular invention. Okay, there is also a declaration by the applicant, okay, or the assignee of the patent. Okay, that means the person who is holding the rights with regard to biological material. So typically, if you see, inventions in your field, inventions in the field of pharmaceuticals, in the field of microbiology and all, we use even botany for that matter. We use some biological materials. Maybe we use some extracts from some plants, or we use some microorganisms. Then those details have to be given here. Okay, you have to declare what microorganisms or what botanical sources you have used. Okay, and then you have to say how many pages are there, how many claims are there, and you have to put in the date, and the agent has to sign all of this. Okay, so this is your basic application form giving details of inventor, title, applicant, type of application, and if there is any biological material used. Okay, so make sure if you are doing this on your own, you give the title properly because it gets published. No, there are no spelling mistakes in your name, and there is no error anywhere in the entire form. Because if it comes erroneously here, it gets published erroneously. Maybe your name is wrongly spelled and you don't like it that way. So ensure that all these details are appropriately filled. Don't forget to tick on the biological material if you used one, because if you don't do that and if you indeed used one, then the patent office can actually reject, or somebody can oppose your patent and tell them that you are not eligible for patent rights on the basis of wrong filling of form 1. Okay, so this is very, very crucial, the most basic, but the most critical and important details go into form. Okay, the sequences. If you're working in the field of computers, you may have computer programs or algorithms or codes that have to be put. So the number of pages are calculated and there may be extra fee involved. Okay. Otherwise, you don't pay beyond the 1,600. This is only extra fee for extra claims or extra pages. Okay. The next form, I have jumped to form 28 because it is very relevant. Because it is form 28 in which you will specify the nature of the inventor and applicant. Okay, so in this you will say whether the applicant, why he is eligible for a small entity fee. Okay, whether you are an education institute, a startup, or an individual. If you're an individual, then you have anyways given in inventor and applicant the individual's name only. But the moment you give the entity's name is the applicant. Okay, you have to justify in Form 28, okay, as to why you're eligible for 1,600 rupees fee and not 8,000. So if you're a startup, you have to submit the Startup India certificate. Okay, if you're an educational institute, your institute certificate, incorporation, or if you're a small entity, incorporation of your organization along with the necessary details and evidences have to be given along with Form 28. Okay, so this is with regard to Form 28. Form 31 is crucial when you are applying for a patent because Form 31 actually allows you to file for a patent application even if you have disclosed your invention, okay, prior to the date of patent application. What I told you initially, that the patent should not be known through any publicly available document prior to the date of the patent application. However, the through Form 31, if you are applying for a patent, it should be within 1 year of public disclosure in any conference or through any publication. Okay, suppose you publish today on 25th July 2025. If you apply for a patent application before 25th July 2026, okay, and you submit 500 rupee fee through Form 31 and say within a year I'm submitting, I am the inventor, I am also the author in the publication, or I am also the presenter in the conference proceedings, then the patent office will consider this declaration and allow you to file the patent application without that particular publication or conference proceedings impacting the novelty or criteria of your invention. Okay, so Form 31 from that perspective is important because you file it along with your other documents, that is Form 1, 2, if required 28, and then 31. Then what is Form 26? Form 26 is, suppose you appoint somebody like me as your patent agent, then you have to give me an authorization letter on stamp paper, which says that I will represent you at the patent office. So I work on behalf of you at the patent office. For you to give me that authorization, the form applicable is Form 26. Okay. Then Form 3. Form 3 is important because when you apply for a patent in India and if you consider applying for patent in other countries, then it is obligatory on you to keep the patent office informed. Okay. So if you make any foreign applications within 6 months, inform the Indian Patent Office, or within 3 months of the issue of the first examination report also, you can tell the patent office where all you applied in foreign countries. Okay. So it is your undertaking that you have applied in XYZ countries. This you do through Form 3. There is no fee for this particular form. Then Form 5, you file again within 1 month of the date of filing of the complete application. And the Form 5 is again a declaration of inventorship. I know that you put the inventors' names in Form 1, but here it is a declaration. Okay, you declare that you are the true and first inventors of this particular invention. Okay, again, you have to file it within 1 month of the patent application, and there is no fee for this particular form. And then there is Form 9, okay, which is a request for publication. Okay, suppose you want it before the 18 months, then you have to request through Form 9. Now, Form 18 is for requesting for early publication. Okay, sorry, early examination. 18 is basically requesting for examination. Once the patent is published, you have to request for examination. Okay, the patent examiner will not automatically start examining your patent unless you request for examination. It will not be examined. Okay, so if you want it to be examined quickly, you pay a little more fee. So 4,000, otherwise 5,600 for expediting, and 20,000 for others, 28,000 for expediting. Okay, you have to do it within 31 months from the first filing date. The first filing date can be a provisional or a complete. Okay, that is what is called a priority date. It is prior to any other date, so it's called a priority date. And within 31 months of that date, you have to request the patent office to examine your patent. Okay. If you want to delay your patent examination, okay, you don't want to expedite it, there is a form 18A for that. Okay, so you have both the provisions available. And then you have Form 8 and Form 8A. Okay. Now, these are very interesting forms. These have been very recently introduced by the Patent Office. 8A is a certificate of inventorship when you apply for the mention of an inventor in the patent document. Say, for example, you forgot to include someone, or you missed including someone, then you can give the reason for missing it, or if there is a correction to be done, you can give the reason for the change, or the name of the inventor. You apply for that in form 8, and then you will get the certificate in form 8A. Okay, so these are the various forms which are put across during, as I said, filing and processing of a patent application. Few more forms in the same theme is form 25, where you request the patent office to file a patent outside India before you file in India. Okay. So what you have to do here is, this there is a particular clause in the Patent Act which says that as an Indian inventor or as an Indian entity, you have to first file in India. Okay, you cannot file in any other foreign country. If you file in India, 6 weeks down the line, you can automatically file without taking any permission in any other foreign country. Okay, 6 weeks from the first filing in India, you can do foreign filing. However, if you want to first file in a foreign country, then file in India, then you have to take the permission of the patent office. And you do that through Form 25. And then finally, there is Form 27, which, as I told you earlier, when I showed you that flow chart, there was a Form 27 in a red box there. Now, the Form 27 is a statement by the patent holder with regard to the working of the patent. So you basically say, which is the patent, who is the patentee, how many units of that particular product you have sold, how much revenue you made in that particular financial year, or did you license it out? Did you license the technology to someone? Okay, what is the status of that license? Who is working the patent? How much units are being commercially available to the public? Now, why do you need to give this statement? Because a patent is a right given to you to prevent others from marketing their product, right? Now, if you don't do it and nobody does it, and if there is a need in the market, okay, the market need is not fulfilled. So it is then up to the government to see how it can be fulfilled. So for them, this statement is important. Okay, now look at it from a medical perspective. Suppose there is a new therapy, okay, a new anti-cancer therapy. Okay, somebody patents it. So nobody else can manufacture it in India or sell it, right? However, if you also don't do it as a patentee, then how will it reach the masses, right? Now, suppose you are facing a problem with the drug control authorities. Okay, then you can put down here that I'm awaiting regulatory approval. I'm not getting an approval, therefore I cannot market it. So then it will be taken up by the government with the regulatory approval. Okay, so this is a communication to the government with regard to the status of converting your invention to a marketable or a sellable technology or product. Okay, so the government keeps track of what is happening with your invention. Okay, so these are the various forms: 1, 2, 5, 9, 18. Okay, 25, 26, and 27. Okay, so these were the forms that were involved, in which you as a patentee or you as an inventor will be involved. Okay. Now, the next set of forms is with regard to opposing a patent or revoking a patent. Okay. Now, when would you oppose a patent? When you find that somebody has a technology similar to yours, they don't deserve to get that patent, or if somebody gets that patent and nobody else is able to sell the product, then the entire country's population will be impacted. Okay. Or you think that somebody has wrongfully obtained an invention from you and you have to oppose it, or you have to revoke or cancel their rights. Okay. Under those circumstances, okay, you can apply for opposing or revoking a patent. Okay, you can also look at it from the perspective that somebody got a patent, They're not marketing that technology, and they're not doing it for a long time. Okay, the government says if somebody doesn't market a patented technology for 3 years, then somebody else can compulsorily come and say, give me a license and let me market it instead of you doing it. You are not ready to do it. You're selling it at too high a price. You're not selling enough quantities. But the public needs much more. They need it at a cheaper price. And you're not giving me a license to enter the market as a competitor. What happens when competition comes in? Price goes less, right? And the buyer has more choices. However, if there is only one party, which is what happens in patent, okay, it's a monopoly. Nobody else can enter the market. But if that patentee is being un you know unjustified to the market, okay, he's not able to justify his price, he's not able to justify the quantities he's producing, then there can be a third entity which comes into the picture and says, give me the license and I will do it. And the government, okay, or the patent office will look at that application and decide whether such a license needs to be granted. Okay, all those are covered through various forms. So if you want to file a opposition, it's form 7. Okay, the representation is in form 7. The opposition is actually filed in form 7A. Okay, then if you want to give a notice for the amendment or restoration or surrender, okay, of a patent, then you use form 40. Now, when do you surrender a patent? Suppose you got a patent grant and you think that the masses will be more happy. Okay, I don't want to commercialize it. Let me give it off to the public for free. Okay, suppose you made a new vaccine and you think, well, I know I have patented it, I've been acknowledged as an inventor. Now I just want the masses to have the vaccine for free. No patent protection around it, no monopoly around it. Let many people manufacture the vaccine and let all the public get it. Okay, then I will surrender the patent. Now, when is a patent restored? If I didn't pay my maintenance fee, as I told you earlier, every year you have to pay maintenance fee for maintaining the patent. If I don't pay it on time, it may lapse. However, there are provisions to restore it by paying extra fee. So there can be restoration of patent rights also. Okay, so you can surrender patents, you can restore patents. Okay, you can cancel or you can, kind of terminate licenses that are given. So for all that, you use form 40. Okay. Now there is form 15 also, which talks about failure to pay fee and therefore you restore it through those means. The earlier form 14 was restoring through if licenses get cancelled and so on and so forth. Okay. The compulsory license that I spoke of, if somebody is not commercializing, you say, I will be able to do it. That is called a compulsory license. Okay. Mandatory one granted by the government and not by the patentee. Okay. So such a license application is made under Form 17. Okay, revoking for non-working patents. So if you see Form 27 for 5 years and you see that the patent is not being worked at all, then you can apply for revoking the patent rights under Form 19. Okay, you have a license, but you want to revise the terms and conditions. Licenses have to be submitted to the patent office. When you revise terms and conditions, you can submit the revisions under Form 20. Okay. And if you want to terminate a compulsory license, that also can be applied for through Form 20. And there is a request for grant of a patent, okay, which is 3 months on the date of issue of the patent. Okay. So what happens here is if your patent has been opposed, revoked, okay, there has been some wrongful process, but you have overcome all of that and your patent has to be granted again. Then you apply for it under Form 12. Okay, so these are more with regard to enforcing your rights. The next set of forms are with regard to patent agent. Okay, so the application for registration of a patent agent. If you pass the exam, you apply under Form 22 and get yourself registered. For appearing of the exam, there is a fee, but there is no form there. It's a simple application made to the patent office. And if your name has been cut off from the patent agent register because you did not pay the maintenance fee of a patent agent register, then you can get it restored by applying in Form 23. Okay. All other matters, I've clubbed all of it. There are a fair amount of it. Okay. Many of them are with regard to the changes you want to make within in the patent application, in the content, in the inventor's name, a change in applicant, change in certain parts of the patent document itself. Okay, then if you want to have extension of time, as I told you, the entire patenting process is a process oriented towards timelines and deadlines. If you miss some deadline for whatever reason, then you can seek the controller's decision on condoning your delay. Okay, so you can request for it in form 4. You can request for certain changes in form 6. If you want to make some amendments, there is form 10, form 13. Okay, all are different types of amendments that you make. If you want the controller's decision in some matter, you can write to him directly through Form 12. And if you want him to keep his order, you want him to overrule an earlier order. Say the examiner has issued an order and you want the controller to keep it aside. Then you can request for that in Form 24. Now, for any reason you want to withdraw your patent, okay, you can do it um, under Form 29 if you have already filed for the request of examination. So you have filed the request for examination, but you don't want it to be examined. Then you apply in Form 29 and say, please do not examine my patent henceforth. Okay. And then if nothing else covers any of it, then you have Form 30. And if you have any complaints against the patent office or any appeal that you want to make against the patent office, then you have Form 31 or Form 32. Okay. So the last set of forms is a majorly procedural. Okay. The first set of forms I think was the most critical for us because as innovators, you should know what are the forms to be done throughout the application process. Okay. So any doubts, anybody at this stage? Because then I'll finish it off at this stage itself. I won't go back to this Word document. I can't see anything in the chat. Lingaraju sir, any questions, anything? Then I can take it now. Otherwise, I'll go back to my presentation.
Yeah, please continue. No, fine. No issue. No one has expressed any doubts in this.
Okay. All right.
Yeah, continue.
Okay. Thank you so much. Thank you.
I want to ask here.
Yeah. Please, ma'am.
We had a like one course, madam,
Uh-huh.
transplant, and we are coordinator where around 33 speakers are there, and all the content of that was a new course which was pioneered by our college.
Okay.
And we have they have issued us a patent only that format is there.
Mhm.
Which we have received from the court.
Okay.
Is from your organization.
Okay.
In case that seal one, which certificate comes of that patent,
Right.
that is still we got it, but anyhow it is misplaced.
Oh, okay.
So, is there any procedure how to get it?
Yeah. Okay. So what I understand, Shettigar ma'am, is that your grant certificate is missing, right? Okay. If you can just drop us a mail because I think currently the patent office only issues e-certificates. Okay. So we could probably go back and trace yours and then share it with you. Or if we can write to the controller for reissue of your certificate, we'll let you know what is the process, what is the fee involved. And then once you decide on it, we can go to the controller and request him to reissue it for you.
Okay, because of what will being that certificate is not there, we are unable to even announce our patent.
Oh, okay, fine. I understand. Of course, you can see it in the patent office website, ma'am. If you know the inventor names, you can search for it, and then you can see the certificate there. So you will know the number and the name and the date of grant and all that. You have any problem? In fact, I would request you just write back to me on my email ID the details, whatever you have. Who applied for it and inventor name. We'll trace it out for you, and then we'll see what is to be done.
We did a procedure from your company, same company.
Yeah.
There, with whom I used to coordinate.
With whom? Jyoti.
Not Jyoti. I'll mail you everything.
Not a problem. Not a problem. So what did they come back and tell you that you can do it?
Okay. Thank you.
Okay. All right. So you can do it. Let's see how it has to be worked out. I'll let you know what we can do from our end. We'll certainly help you out.
Okay. Thank you.
Yeah. Okay. All right. Thank you for that. Thank you for allowing me to go through these 32 sections. I'm going back to my presentation. Uh, okay, I hope you can all see it. So we finished with this one. Now I come to the art part of the title that was given to you, the art of patent file. Okay, there is a law part of it. Then there is a science, because your invention is basically a science. So you will disclose a scientific technology to your patent agent. Okay, and there is a law part of it, which is what is put in this slide and the following slide. However, the ones after that will talk about the art part of the patent file. Okay, exactly what Ningaraju sir spoke about in terms of what is the requirement in a patent. Okay, now what does the law say? The law says that the patent specification, okay, the document where you disclose the patent and file it at the patent office is called a patent specification. Okay, now it says that every specification should have a title. Okay, it can have drawings which are part of the patent specification. Okay, so if you're typically having some device, or if you're, say for example, even simply filing for the patent application of a pen, okay, then you can describe, or you can bring out the features that you want patented through drawings and then support it with text. Okay, so that is perfectly allowed in a patent application. So devices, then engines, or electronic instruments, all these apparatus that we use, all that, that you as nurses use so many devices, right, from stethoscope to beds to injections, then you have testing apparatus, you have all your pathological instruments, all those can be described through drawings. So drawings are considered to be part of the patent specification. Now the question is, if you make an innovation, are you expected to create a sample of it or a model of it, then take it to the patent office before you file for a patent application? The reply to that is no. Okay, it is not possible. Suppose I invent a new car, am I going to drive it to the patent office to show it to the patent examiner? No. I am allowed only to use that particular patent document which I filed at the patent office to describe my invention. I can take the help of drawings, okay, but I cannot take any other help. Okay, no models or samples are allowed, no videos are allowed. You can put pictures there, you can put drawings there, and you can describe them in detail. Okay. However, if for any reason the patent controller feels that he wants to have a look at the model, he can ask for it. Okay, but it is not part of the patent specification. Okay. Now, what the Act further says is that your invention should be completely described, fully described in the patent application. Okay, so there has to be a full description of the invention. Okay, and you have to say which is the best way of adapting your invention. Okay, so you may have various variants of your invention. Okay, you can say that you can do something and there will be 30% success. You can do in a certain way, there will be 60% success. However, if there is a best way in which you get 85% success, that way has to be disclosed in the patent application. Okay, so the best method of performing the invention should be included. And every patent, particularly complete patent specification, should end with a set of claims defining the scope of the invention for which protection is claimed. Okay, look at the bold part in bullet C. Okay, now what do you mean by claim? The claim is the legal part of the document for which you are seeking protection. Okay, in the entire patent specification, you are describing the invention, there are drawings. Okay, then you're writing a summary of the invention, you also have to write an abstract. Okay, but the part which gives you protection, the part which gives you the rights to exclude others, that part is called claims. And while the rest of the patent application, okay, is having a scientific description of the invention. Okay, you have to describe the invention with regard to the science behind. However, the claims will be written in legal language. Okay, there is a certain style of claim drafting. Okay, there is legality to claims. Claims are the ones that you're enforcing, and claims are the one that protects you from, from others to copying your invention. Okay, therefore, writing the patent, okay, is a combination of science, law, and art. Okay, and the claims part of it is a legal part. Okay, that is why you need specialist patent drafters. That is why you have patent attorneys and patent agents, because they understand how to represent this in the best possible way. Remember, as I told you earlier, this has to be enforced for 20 years, so the legal part of it should be really strong. Okay, and the patent act says that there should be an abstract, okay, which provides the technical information of the invention. An abstract is basically a 150-word short description of the problem that you have and the solution that you're given in terms of your innovation. Okay, provided that the controller has the right to amend the abstract. As I told you, the biological material has to be disclosed in the patent application, and according to the patent act, you have to deposit it in what is called an international deposit. Okay, so suppose you have a microorganism which is new, you're expected to give it to the government as a sample. Okay, and you have to include that sample deposition in your patent application. And that sample can be accessed by others who want to conduct research using the same sample. However, that will not be done before you apply for the patent. Okay, it will not be given to anybody just like that. And you have to disclose the geographical origin of your biological material, from where you accessed it or from where you obtained it. You have to disclose that. So these is all the act says. Okay, now just by reading this, you'll not be able to draft your patent. Okay, so what exactly otherwise goes into the patent specification? Of course, the title, right? Then you have a section which is called the background and prior art. Okay, prior art, as we said earlier, are documents in public domain which are, you know, eligible to impact, the examiner's opinion on your patent. Okay. Now, what do you write in the background and prior art section? Okay, in the background and prior section, you lay the context for the invention. Okay, you say that let us assume that you have an invention which is a medicine to treat diabetes. Okay, just giving you a random example. Okay, so then you will say that according to the World Health Organization, there are so many billions of people who are suffering from diabetes globally, and the anti-diabetics market is of this size. Okay, there are many drugs that are eligible or available in the market to treat diabetes. Okay, so you talk about, say, right from glibenclamide to metformin to the gliptins, whatever are the new drugs that are available. Okay, your glutide, the semaglutide, and all, which have come now. And then you will say, of course, there is insulin. So you will give this background. And then if your invention is around insulin, then you will say that insulin is a molecule that's known for 100 years, but it is always given in injectable form. Okay. Now you are presenting a problem. Okay. And you say that everybody cannot take injections. There are children who have type 1 diabetes and they have to be given, preferably given something orally, while insulin gets degraded when it's given orally. Okay, so this is your problem statement. What are you setting the stage for? You're setting the stage for saying that this is the problem and I have a solution to this. Okay, okay, they have very bad taste and odor. So when a child is forced to eat it, he's not a very happy patient. So when a child is forced to eat it, he's not a very happy patient having it. Okay, so you're presented one more problem. First, you have to give orally. Second, you have very bad tasting, bad smelling, big molecular weight peptides and proteins, which are not easily soluble. Okay. Now, what do children like? Children like sweet, nice smelling, orange or strawberry flavored or cherry flavored or ice cream flavored kind of products. Okay. So that is your innovation. You have been able to make a good smelling product, which is appealing to a certain section of the population who are suffering from diabetes. Okay. So you have set the stage for your invention in the background and prior art section. And you have said there is a problem and nobody has been able to solve it till the date of my patent application, which means there is no relevant prior art till I have invented this particular invention. So, what are your objectives? Your objectives are to present oral form of insulin and to present it in a form which is appealing to the pediatric population. It should have good flavor, good taste, and good odor. Okay. Now, in the summary, you'll briefly write a paragraph, describing your image. Okay. Now, here there are no drawings, but if there are drawings, you have to write what your drawings pertain to. But the detailed description of the invention will give all the details. Okay. So you will say what is your insulin mimicking molecule or protein or peptide or amino acid or whatever. Okay. You will describe or you disclose it in detail. If you have amended some amino acids in a chain of them, you will give each chain that you have of that particular molecule. Then you will say, the one in which there is no alanine works best or something like that. Okay, you will say, you'll have a statement which says which is the best embodiment. Then you'll say, I used all these different types of flavors. Okay, I used cherry, I used banana, I used vanilla, I used orange, whatever, strawberry, mulberry, raspberry. Okay, I've tried all these flavors. Then you'll say, to sweeten it, okay, I have used sorbitol, glycerine, sugar syrup, and then artificial sweeteners like saccharin, and then safer sweeteners which are natural like stevia. You also added glyceriza, which is a sweetener. You can add, you describe all this. Then you'll give experimental details on how you prepared that syrup. Okay, how much of quantity of each ingredient you took, how you heated the sugar syrup, you dissolved the peptide, then you cooled it. All those experimental details you give in examples. You'll give whatever advantages you have of the invention. Okay, you'll say that now you have a sweet, nice smelling, more appealable product. Okay, you'll write an abstract in within 150 words. You're supposed to say that oral insulin is not bioavailable. Injectable insulin is not very convenient to administer to children. And then to make it a more appealable product, you are presenting this image. And then you write the claims. You can, of course, include the drawings if any. And then you write the claims. Now, what is a claim? As I told you, the claim is the part that protects your image. So, what is your claim here? Orally administrable insulin like product to administer to pediatric patients containing, okay, whatever is your insulin mimic product and whatever is the dose of it, okay, or percentage in that product. Okay, so you can have probably 1 to 10% is that particular ingredient, and then you say how much sweetener is there, how much flavor is there. In the first claim, you'll only write sweetener, flavor, or any buffer or any odor, killer and all, and water, if it. Then in the second claim, you will say the orally administered insulin that I have described in the first claim, where the sweeteners are glycerine, sorbitol, sugar syrup, stevia, saccharin, etc. Okay. Then in the third claim, you say the flavors are mulberry, raspberry, strawberry, etc. etc. Then you can write another claim, you say, where the preferred flavors are raspberry and strawberry. Okay, so you narrow down further. Okay, then you say the preferred sweeteners are sugar syrup and stevia. Okay, you narrow down it further. Okay, so you go on narrowing it down to your best embodiment. Okay, and this is the claims for which you are done the innovation, and your patent will be granted if this is not known before the date of invention, and it has got some other criteria to be fulfilled. I'm not going into too much detail